Hello and welcome to the FedSoc Forum webinar call. Today, July 23rd, 2025, we're delighted to host a discussion on current issues in church autonomy doctrine, categorical immunity, collateral order doctrine, and neutral principles of law. My name is Kayla Kleist, and I'm Deputy Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we will keep the introduction of our guests today brief, certainly more brief than their careers would deserve. So I highly recommend that if you're interested, you check out their impressive full bios at fedsoc.org. I'll go ahead and introduce our moderator, and then I'll leave it to him to introduce our panel. Today, we are fortunate to have with us Judge Brantley Starr, who serves as a federal district judge in the Northern District of Texas, where he has served since 2019. Before that, he was Deputy First Assistant, Attorney General of Texas, and served in various roles in the Texas Attorney General's office. He also clerked for Don Willett, then on the Texas Supreme Court, and he teaches originalism at Texas A&M University Law School and SMU Stedman Law School. A last note before I get off your screens, if you have any questions throughout the program, please do submit them via the question and answer feature, like we found at the bottom of your Zoom screen. We'll be accessible when we get to that portion of today's webinar. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Judge Starr, the floor is yours.
Okay, thank you, Kayla and Federalist Society for hosting this discussion. The church autonomy doctrine dates back to 1871, and you might think that we courts would have settled the key issues in this area by now, but you would be wrong. There are key things floating around, like when we courts are supposed to defer to churches. Agency deference, choice of word habit. When we are supposed to defer to our churches, and when instead we're supposed to apply neutral principles. But we courts haven't really drawn the line clearly and adequately in all the contexts in which these disputes can arise. Maybe you should give us another 150 years and then we're bound to figure it out. But we have a very good panel today to hit this topic from a variety of angles. First, we're going to hear from Professor Carl Esbeck. Carl joined the University of Missouri Faculty of Law, where he's now the R.B. Price Professor of Law Emeritus. He published Disestablishment and Religious Dissent, Church-State Relations in the New American States, covering 1776 to 1833. It's a historical account of disestablishment in the original states, as well as Spanish Florida and French Louisiana. And relevant to our topic today, just a few weeks ago, Carl published Church Autonomy, Textualism, and Originalism, SCOTUS's use of history to give definition to church autonomy doctrine. That's in the Marquette Law Review. Then we'll hear from Martin Nussbaum. For 40 years, Martin has advised and advocated for Catholic dioceses, religious institutes, and a host of Protestant, Jewish, and Hindu groups. Martin has a national reputation for his experience in religious freedom. He has served for years as a consultant to the U.S. Conference of Catholic Bishops' Religious Liberty Committee and as general counsel for the Catholic Benefits Association. Martin has advocated as trial, appellate, and amicus counsel in landmark First Amendment and RFRA cases in the U.S. Supreme Court and the state and federal courts across the country. Martin founded the Federalist Society chapter at the University of Texas Law School that I got to be a member of when I was there. He's also a founding partner of First and 14th, PLLC, a boutique law firm with offices in Colorado Springs, Denver, Kansas City, and Washington, D.C. But apparently, Martin, you're discriminating against Texas by not having an office there. I won't hold that against you today. First and 14th focuses on religious institution law, public and election law, commercial litigation, and First and 14th Amendment rights and other constitutional rights. And third, we'll hear today from Eric Rassbach. He is Vice President and Senior Counsel at Becket Fund for Religious Liberty, where he has served since 2003. He's briefed over 100 cases at the U.S. Supreme Court and has led or been a part of Becket's litigation teams in Hosanna Tabor, Hobby Lobby, Holt versus Hobbs, Zubik versus Burwell, Agadath Israel of America versus Cuomo, Fulton versus Philadelphia, and Montbooth versus Taylor. In 2020, Eric argued Our Lady of Guadalupe School versus Morrissey Baru to the Supreme Court and garnered a 7-2 win. And in 2025, he argued Catholic Charities Bureau versus Wisconsin Labor and Industry Commission and got a 9-0 victory in that case. Eric has also briefed and argued cases in federal appeals courts and state Supreme Courts across the nation, as well as the European Court of Human Rights. And batting cleanup, we have Hiram Sasser, who is the Executive Counsel for First Liberty Institute. Executive General Counsel for First Liberty Institute. Sorry to omit a key word there, Hiram, where he oversees First Liberty's litigation and media efforts. Sasser's practice focuses on First Amendment and other constitutional and civil rights issues relating to religious liberty. Hiram served as co-counsel in 7 victories before the U.S. Supreme Court. In 2016, Hiram took a leave of absence to serve a temporary assignment as the Chief of Staff for the Attorney General of Texas, where, in full disclosure, he was my boss. He currently serves as an adjunct professor of law at both the University of Texas at Austin School of Law, teaching religious liberty, and Oklahoma City University School of Law, teaching civil rights. Okay, and as far as procedure, we all know the order that we'll hear our panelists from, but we'll do opening rounds, perhaps 10 to 12-minute ballpark each, and then I will open it up for more of a battle royale at the end, where all of our panelists can discuss topics that piqued their interest that other panelists brought up. So, Carl, I'll tip it to you first, and we've all agreed to go on a first-name basis, so that's why I am offending Professor Esbeck. We just thought it'd be simpler to keep our first names in play, although I know our panelists sometimes struggle with calling judges by their first names. My birth certificate says Brantley, so green light for everyone to use my first name. All right, Carl, let's hear from you on opening statements.
Thank you, Judge. You see, I avoided their choosing between first names and last names. It's just really hard to call a judge by his first name. So, Judge.
That was artfully done, very artfully done.
Well, since I'm the first panelist up, it falls to me to somewhat frame this issue. I should first say the 4 of us were picked. We're pro-religious liberty, but it's thought that we differ as to the church autonomy doctrine. So church autonomy is not widely or well understood. And it's a third way of getting religious liberty under the First Amendment. It's the third way. The traditional way, of course, is the Free Exercise Clause and the No Establishment Clause. That's what we learned in law school. But this is a third way, and I think it helps your understanding of Supreme Court case law if you think of it as a very distinct, individually separate way of getting religious liberty from the First Amendment. It's quite different. It's often identified as a categorical immunity. So if it applies, the case is dismissed. That's it. No shifting the burden to the government to do strict scrutiny. It's a good way of thinking about it is that it's about subject matter limits on government power, just a few subject matter limits, which have been identified by the U.S. Supreme Court, and I'll get to those subject matters in just a moment. I like to call church autonomy a structural immunity. I want to use the word structural because as we learned as we took up constitutional law in law school, we learned that there's a 50-50 division in that study. It's either rights or structure. And we think of structure, of course, separation of powers, federalism, checks and balances. Here it's separation of church and state, which is a structural thing. So there are certain areas, subject matters, which are given over to the autonomy of the church. There are also reciprocally certain subject matters that are given over to the exclusive power of the state. For example, the sword or the coercive power of the law, that never lies with a church or other religious body. So, and before I again go to those 4 or 5 subject matters or zones of subjects, which the Supreme Court has identified as under the church autonomy doctrine, whenever we talk about giving any individual or entity absolute authority, we get nervous. But of course, judges have absolute immunity when they operate arguably within their subject matter jurisdiction. States have sovereign immunity. The president has unchecked pardon power. Congress has absolute authority if they're speaking within the speech and debate clause. So there are little pockets in the Constitution of absolute authority. And this is one for religious entities, certainly churches, but it goes beyond churches. But there's a warning there. Our society, our governmental arrangements is willing to give absolute authority as long as it's kept relatively confined, like Lord Acton's aphorism, power corrupts and absolute power corrupts absolutely. So if litigators pushing for church autonomy try to push that doctrine too broadly, I would fear a reaction from the judiciary and society in general. So it's important that you not over ask. That's my warning to the practitioners. So I'm going to mention 4 subject matter areas. The first is religious disputes or religious questions. The government does not take sides in theological questions. We say the magistrate has no competence in religious matters. Or we could simply say in America, there are no heresy trials. Second, polity. Religious bodies get to pick their own polity. It may be top down, like a for-profit corporation. It may be from the bottom up. It's common with Protestant groups in America to be membership driven. So the final authority within a church is the members at a duly called meeting where a quorum shows up, and the majority controls, and they make all of the final major decisions for that religious body. Whatever polity they pick, and most of them are somewhere in between, that's a unilateral matter, and the state or government is to defer to that choice of polity. Third is the employment of ecclesiastics, pastors, priests, ministers, and religious functionaries. This comes under a heading called the ministerial exception. Probably best not use that term, but that's what we're talking about here. And then fourth is membership criteria, membership in the church or other religious body. What is the criteria to get in? What sort of offenses do you have to do to be dismissed or excommunicated? What does it take to be a member in good standing so that you can show up at a meeting and have a right to vote because you're in good standing? And all of those questions are matters entirely within church autonomy. Now, the consequences of something being in church autonomy, well, it's a threshold issue for the trial court. If it's usually raised as a defense, so if the defendant raises it, the trial judge needs to deal with it at the outset, because if it is a matter within the subjects, one of those 4 subjects or 5 or 6 subjects that are within church autonomy, then the case dismissed. It's over. On the other hand, if it's not within one of the subject matters of church autonomy, well, then the case goes on. But there's no balancing. It's a categorical dismissal. So we say church autonomy is a bar to being sued. It's not simply an ordinary defense to liability. Second thing is interlocutory appeals. Say the trial judge looks at whether it's in church autonomy and decides that it's not in church autonomy. Well, if the church or religious body disagrees, can they take an interlocutory appeal under the collateral order doctrine? The federal circuits are split. And it's really a question of application of the collateral order doctrine, but I think the better ruling is church autonomy indeed is within the collateral order doctrine, and there should be an interlocutory appeal. We, as panelists, may find a difference of opinion there. The next point is, in church autonomy, you do not have to show religious injury. If you take one of the leading cases, Hosanna Tabor, a 4th grade teacher at a religious school was dismissed she says, because of her disability. So she sued for employment discrimination under the ADA. And it would seem to be an open and shut case, but the church claimed church autonomy and convinced the Supreme Court that this parochial school teacher was a religious functionary and thus fell within the church autonomy doctrine. But the plaintiff said, wait a minute, the church has no religious injury, which is true. The doctrine of the church running the school had no doctrine that said, we have to, as our religious practices, fire every teacher that's disabled. That's not our religious doctrine. But it doesn't make any difference that there's no religious injury. That's not what church autonomy is about. Church autonomy is about autonomy. So the question is, was this particular subject of the lawsuit within one of the 4 or 5 subject matters? It was. It was employment of a religious functionary. End of case, dismissed. Then the last thing I'll mention, because I expect I'm short on time, is you cannot waive this defense. It's because it's structural. It's, of course, individual personal rights under the Constitution, like freedom of speech or free exercise, you can waive it by simply not raising it in a timely fashion. Not so with church autonomy, because it's structural. It's like a federal court, which is a court of limited subject matter jurisdiction. If the defendant fails to raise that defense, it's never waived. It can be raised at any time, even on appeal for the first time. And or a court can raise it sua sponte. So it's structural. It can never be waived. That's come up in some of the cases. And again, those who don't understand the unique nature, I would say a reminder, structural nature of church autonomy aren't going to get this right. With that, let me turn it over to Martin Nussbaum.
Thanks, Carl. Always good to hear you. And I'll just say to everybody, I consider myself a disciple of Professor Carl Esbeck, who really got me started in my church autonomy arguments over the years. Let me say a couple of things. First, this doctrine is really important. In fact, I think it's the strongest of the First Amendment freedoms. Why? First, as Carl has pointed out, it ensures to the church and other religious societies that they are sovereign over a wide range of ecclesiastical subject matters. Secondly, it's rooted in both the Establishment Clause and the Free Exercise Clause. Thirdly, it's the premier First Amendment freedom because it's not even circumscribed by strict scrutiny. There's no weighing of a government's competing interest. And the doctrine is also not subject to the Smith regime. And finally, as Carl has pointed out, it's part of the genius of the American constitutional order in that it acts as a structural restraint on government power. Now, the scope of the doctrine is broad. Carl has identified 4 or 5 subject matters, ecclesiastical subject matters. But when I think of the scope of the doctrine, I think not only of ecclesiastical subject matters, but the types of institutions that are protected, the types of positions within those institutions that are subject to the doctrine, the types of claims that are barred, and the branches of government that are bound by the doctrine. With regard to the ecclesiastical subject matters, I would add to Carl's list 6 other subject matters. First, worship and religious rites and gatherings, including the administration of church buildings and other sacred spaces. We saw that during the COVID litigation. Secondly, the definition of ecclesiastical standards of care. So by my last count, there were 39 cases in different states that barred claims of clergy malpractice and breach of fiduciary duty because the government can't get involved in defining the standard of care. There should be similar unanimity, in my opinion, with regard to negligent supervision, negligent hiring, and negligent retention. Those cases are because of the sexual abuse scandal split about 50-50, though the more recent are tending not to respect the freedom. Thirdly, the relationship between a church and various factions or associations, religious orders or groups within the church is protected. The church is sovereign over that. Next, ecclesiastical communications and confidences. If we have time, I'll love to talk about the Bryce case that I litigated some years ago before the 10th Circuit, which has a host of ecclesiastical communications over which the church is sovereign. Next, the ecclesiastical tribunals. There have been cases where individuals felt injured. One that I litigated called Purdom versus Purdom in Kansas. And tort claims were filed in the civil court after statements that were made in the ecclesiastical tribunal. And lastly, I would say there's some really interesting discussion in the Bryce case when the plaintiff's attorney came to realize the power of the ministerial exception. She amended the case to add the principal plaintiff's partner, a woman named Reverend Sarah Smith, to the case to argue that she's not a minister of the church, she's not involved in the church, she's not a member of the church. And the court held that we have to look at activities rooted in religious belief are also going to be protected. Now, with regard to the breadth of the doctrine with regard to institutions, it goes well beyond churches. It includes religious orders, hospitals, schools, colleges, campus ministries, hospitals, social service agencies, and others. With regard to positions, the ministerial exception doctrine has identified a lot of different positions within religious societies beyond ordained ministers and individuals that would have names like pastors and even the ministry name. It also applies and bars a huge variety of claims, including claims of contract, discrimination, defamation, tort, claims under the statutes like the Title VII or the National Labor Relations Act, the Fair Labor Standards Act. And finally, it's clear that it applies to all branches of government, all three branches. Let me say a bit about the Jones v. Wolf case, which provides a narrow alternative to the rule of ecclesiastical deference pronounced in Watson. That it is quite narrow. It is limited. First, that case says that the normative methodology for deciding these cases is ecclesiastical deference. Jones v. Wolf says it's limited to church property disputes. It has a restrictive rule of evidence, documents that can be considered by a court, not testimony, which proved to be very important in a case I handled on behalf of the Chabad Lubavitch Jews in Connecticut. And finally, the case says that the court's analysis must be, penultimately, the court's analysis must be completely secular. This is all but impossible if one of the documents considered is ecclesiastical law that's drenched with religious concepts. And finally, the court says specifically that disputes involving competing factions are not eligible for resolution by the neutral principles analysis, but there must be hierarchical deference. Now, Jones v. Wolf, the underlying case, I would also point out it's a 5-4 weak, erroneously, and patently unworkable decision. I have already said that it's irreconcilable to use neutral principles to review ecclesiastical documents. And secondly, it just doesn't work. That case on remand to the Georgia Supreme Court, where the Georgia Supreme Court was supposedly applying neutral principles, had a state statute that had a presumption of congregational governance, and it held that using neutral principles that the Presbyterian Church was congregationally governed, when in fact it's hierarchically governed by layers of representative bodies. And finally, the case was supposedly limited to the ownership of property, and that wasn't even the issue in the case. The issue had to do with which faction. So with that, I'll stop and look forward to further discussion.
Very good. Thank you, Martin. Okay, Eric, you're batting third, so you take us away.
All righty. Well, I think thank you for having me on, and to FedSec and to Judge Starr. Sorry. I think already you can see from both Carl's and Martin's contributions that this is a very broad area of law and a broad area of litigation. And I agree 100% with Carl's statement that it's sort of a third way within the religion clauses. So you have free exercise claims and establishment clause claims, and then you've got this third way of church autonomy claims. And I think within that, there's if you want to think about the taxonomy a little bit further, there's sort of a family of different doctrines within the church autonomy umbrella that are going to sort of be a little bit textured and, you know, maybe be a little different in different situations. And maybe we can talk about that during the Q&A. What I wanted to do, just from my standpoint of being a litigator that brings church autonomy claims and church autonomy defenses, that is to kind of give an overview of where I see things going in the next, you know, the near to medium term in litigation in this area. And so I'm just going to sort of try to hit those things quickly without going over my time limit. And I'm gonna hit 6 areas, but I think that there's really many more. And you know, we're obviously already giving the group tons of lists, but here's my list of stuff that's coming down the pike. The first one is the issue of non-ministerial employees of religious organizations, churches, synagogues, etc., and church autonomy. And this is a very live issue with a lot of cases going on. Sometimes there are cases where the plaintiff is, you know, in my mind, clearly a minister, but they claim not to be a minister, or say that somebody said at some point in the past that they weren't a minister. The question is, where does church autonomy apply in those situations? My colleague at the Becket Fund, Luke Goodrich, has a forthcoming article in the Notre Dame Law Review that's on SSRN, and I think is going to get sort of summarized on Volokh conspiracy. And there he talks about, what do you do with these cases where, you know, let's say it's a janitor at a church or a religious school, and something they're doing is interfering with the church's operations. You know, what do you do with that person who's clearly not a minister? And you know, he talks about 6 different ways you could kind of respond to that in the law, and I think settles on, you know, as the lead one, of part of church autonomy doctrine as really the best way to respond to this kind of a, you know, employment dispute where the janitor says, I was, you know, let go because, you know, I'm, you know, different race, and the school says, well, actually, it's because you were wearing anti-Semitic T-shirts to our Jewish day school or something like that. So I'd encourage people to look at that article, because it's really quite a deep dive on the issue. But that's a live issue going on in many cases around the country, and I would not be surprised if it arrives at the Supreme Court at some point in the near future. You know, another one that's very much a live issue is civil corporate structure and church autonomy. In the Catholic Charities Bureau case that we recently litigated at the United States Supreme Court, we brought a church autonomy claim on behalf of our clients. And Justice Thomas, the court as a whole didn't reach the issue, decided it on other grounds, but Justice Thomas wrote a really fascinating concurrence on the topic, where he, you know, talked about the idea of, like, what do you do when you have a corporate structure that, you know, the government's relying on to essentially impinge on church autonomy. And he has a memorable line, the corporation is made for the church, not the church for the corporation. So I'd certainly encourage people to read that. Really great deep dive on church autonomy doctrine. Justice Young on the Texas Supreme Court wrote a really great opinion about corporate structure and church autonomy in a case called SMU, Southern Methodist University against United Methodist Church. Got decided a few weeks ago, and that one is also just a fascinating kind of deep dive on how church autonomy claims work in the corporate space. So that's the second area. Say a third area is clashes between church discipline and civil law. So this would be something I would add to Carl's list, and that is, you know, when there is discipline within the church, you know, there's a certain kind of church law or church rules, or, you know, rules of a particular, you know, synagogue or temple of some variety that people are supposed to comply with, and then they aren't, and then the authorities within the religious organization, you know, explain that there's a problem there. Can that be, is that protected by church autonomy, those kinds of actions, or not? And that has, Hiram and I actually are co-counsel on a case where we brought a church autonomy claim in the Western District of Washington against a rule that would interfere with church discipline, and specifically the way that Catholic priests hear confession and the way that their bishops relate to those priests. And so discipline is, in our view, very much part of governance. And so I think that that's an issue that's coming up around the country, and I think is going to be certainly litigated in a number of courts in the coming years. A fourth area is the timing of church autonomy claims and defenses, and this was already discussed. It's sort of alluded to in the title of this panel, but what happens when the case, the lower court says, well, church autonomy doesn't apply here. Can you immediately appeal that, whether it's based on a jurisdictional ground or sort of something like qualified immunity, sort of akin to that? And that there's definitely a big circuit split over that issue. We have a pending en banc petition at the DC Circuit, rather, on that issue in a case called O'Connell against United States Conference of Catholic Bishops, where we say, we should be able to immediately appeal. The panel ruled against us, so we're seeking en banc review. And then there's also some really fascinating concurrences in the recently decided Huntsman case out of the Ninth Circuit, one from Judge Bress and one from Judge Bumate. They actually kind of disagree with each other a little bit about the exact way the church autonomy works in a case like that. That's a case involving tithing in the Mormon Church, and there's some just really fascinating discussion of that, and I think that's going to be coming up around the country. There's sort of a related area of law here, which is these tithing clawback claims in church autonomy. That's the fifth area I wanted to just mention briefly. The Huntsman case was that. Huntsman said, I gave money to the Mormon Church. They used it for something different than they said they were going to use it for, so I want my millions of dollars back. And the Ninth Circuit rejects that en banc. But there's actually a number of these cases around the country. Church autonomy is clearly implicated. What happens when, how much control does a church get over the tithes or offerings that it receives? And then finally, which has also been adverted to, is just the scope of the neutral principles doctrine. We at Becket have taken a very strong position that neutral principles can only be applied in the church property dispute context. But we are increasingly seeing folks say, oh, this applies here, this applies there. But really, in our view, it can only be applied in the area where it was brought up in the Jones against Wolf case that Martin mentioned. It's not something that can be allowed to sort of spread out of that area. We had a case at the Texas Supreme Court a few years ago called In Re Diocese of Lubbock that really addressed that issue. And our opponents tried to say, oh, well, neutral principles means that, we win this case, and we had to sort of try to beat that back and just say neutral principles doesn't apply here because this is not a church property dispute. So, and there's actually a really excellent dissent from Judge Park from en banc. It's really a dissental in an rebellion against Capral involving the Russian Orthodox Church a couple of years ago. So there's actually a lot more issues out there, and I've already probably gone over my time, but I just wanted to say it's really very much a hot area in religious liberty litigation. And certainly if someone were a law student or a law professor looking for something to write about, the fields are ripe for harvest in that area of church autonomy litigation. So I'll stop there.
Very good. Thank you, Eric. And we will have more time to get to your next tier of issues here in just a moment. We've got plenty of time. I'll say FedSoc allocated 187 minutes to our panel today. Joking, it's actually 75. So we've got 15 more than the normal 60. Hiram, I know you told me you got an 18-point list that you wanted to cover. I'm joking. Hiram, you're batting cleanup. What do you want to say in response to your panelists so far?
Well, I want to talk a little bit about neutral principles because, I think we at First Liberty have a little bit of a disagreement. It's not a major one, but a little bit of a disagreement with Becket about the application of neutral principles. And I want to go back historically to talk about sort of the evolution of the law at the Supreme Court on really what are church property type disputes. The first one I want to talk about, obviously we've talked about Watson versus Jones in 1871. Now this was, by the way, it was just 3 years after the 14th Amendment. And so you might be just trying to figure out like, well, this was all went through the Kentucky state court system. Like how does the Supreme Court end up with this jurisdiction in the application of essentially a doctrine grounded in the First Amendment? How does that apply? The incorporation doctrine wasn't really on the scene yet. And so the reality is that this is such a core principle of constitutional law, such a core principle of sort of the structural foundations of our nation, that religious liberty has the Supreme Court recognized we can't have civil courts getting involved in religious matters. And that was actually a church property dispute that was resolved not through neutral principles, but through deference to the higher Presbyterian authority. But to just kind of speed up and get to the little more modern era, in the 1952, you might recall, or at least reading about it, if you weren't around back then, there was that was really the height of the Cold War, in a sense that there was a lot of concern about how the Soviet Union was going to behave itself, and the Russian Orthodox Church had undergone obviously a transformation from 1917 after the Bolshevik Revolution, in which the church began to be controlled essentially by the communists running the Soviet Union. And they had their little outposts by way of the migration of Russians to the United States, first starting in Alaska, down the West Coast, and eventually to the major cities like Detroit, Boston, New York. Whereby essentially the KGB, those are really nice little safe houses and places from which to launch operations. Or at the very least, we're just going to control the doctrine there. And so the American churches that were part of the Russian Orthodox Church essentially attempted to break away. And they were aided and abetted in that process by the state of New York, passed a law to make sure that property, St. Nicholas Cathedral, for example, in New York, would be under the control of an American bishop and not under the control of Moscow. So if there was ever a case where the interest of the United States and maybe religious liberty, if you might think about it in a very narrow sense, under neutral principles, this is a law that was passed, duly passed by the state of New York. It's a statute allowing the property to be controlled by the American church, the American versions of the bishops there. And the Russian Orthodox Church from Moscow said, no way, those are not our people, that's our property, that's our leadership positions, and we challenge that and we control that, not them. If you would think, that would seem to me, when we're talking about the survival of the nation, that would seem like one of the utmost government interests to override the deference model. But yet 8-1, the Supreme Court said, no, we're going to defer to essentially the Communist Front Church in Moscow. And we're going to give them authority over those American-based Russian Orthodox churches. That's how important the church autonomy doctrine was seen by the court. And so if you fast forward to 1976 in the Serbian Orthodox Diocese versus Milivojevic, that was also a majority case. That was 7-2. In favor of the deference model. But most importantly, and sort of illustratively, Justice Rehnquist was in the dissent. And he essentially, that case was really about, whether it was more than just it wasn't necessarily about church property, although the control of the property would be sort of an offshoot of the case. But it was really about the defrockment of a bishop, and Justice Rehnquist in the dissent said, well, if we just let these, if we just defer to whatever the church says, it's who brute force wins. And he said, well, and that was his argument for neutral principles. He said, we can interpret canon law here. We can decide who the proper leader is. But in 1979, in Jones versus Wolf, that Martin referred to, that case, Rehnquist finally had a majority. It was 5-4, and to apply neutral principles. But a lot of people talk about Jones versus Wolf as, okay, neutral principles are okay in property disputes, but its origin is a church leadership dispute. The origin of the idea is about church leadership disputes, where the other side has always been on the losing argument up to 1979 that neutral principles could be applied. Because the argument always was that if we don't apply neutral principles, then somehow might makes right, and just whoever decides that within the church autonomous sphere would get to decide it, and there would be no review. And that didn't seem to sit well with some. Martin had a good explanation for Jones versus Wolf. I won't get into that, but other than to say that there's been a drift as the secularization of society, and Carl can even reference this a little bit. The secularization of America we've drifted away. I highly doubt Keydroff or its sister case, Kreshik, would actually be decided the same way as they were in 1952 and then Kreshik in 1960. That was not a statute, but a court by court order. The same issue, can the Russian Orthodox Church from Moscow control? And they said no. Courts can't decide that any more better than legislatures can. But I think that the secularization of our country has led towards a dabbling in neutral principles that once out of the bag is just going to metastasize to other areas. And so I think it actually needs to be nipped in the bud at the source, and that even with these church property disputes, we need to go back to the way we viewed religious liberty in 1952. And our country didn't fall apart. We won the Cold War. I think it will be fine.
Mm-hmm.
Well, Hiram, thank you for closing us out on opening statements. I would say this is to Carl next. I guess the hallmarks of due process are notice and the opportunity to respond. So you've had your three co-panelists go and not a word you've gotten in. So what do you want to say that's piqued your interest, Carl, that they have said, or what material did you not really get in your opening that I didn't let you to because of my time constraints?
Well, let me start with neutral principles of law, which I didn't get into at all. Hiram and I indeed disagree. There's been, at the Supreme Court level, there's been just 3 neutral principles cases: the Presbyterian Church case versus Bluehall, Mary Elizabeth Bluehall, the Maryland and Virginia eldership case, and Jones versus Wolf, which has already been mentioned. All of those were property dispute cases, and that's the only kind, and they're all the same, that's the only cases where the Supreme Court has allowed neutral principles of law. Now, by property dispute, let me draw that out just a little bit. So you have a religious body, a church, there's a schism, you end up with 2 factions. And it makes no difference whether the schism is doctrinal, how to interpret the Bible, or some other issue. The point is the 2 factions are now not even trying to reconcile. But the question is, who gets the valuable property? Because whichever faction gets the valuable property is going to have a lot easier time surviving going forward. So the Supreme Court said, as to that property dispute, a state may apply neutral principles of law. but the limiting principle on neutral principles is you can't do judicial deference in that situation because each faction says, I should get the property because of this provision or that provision in the church polity. But they're each pointing to different provisions in the church polity. So they create a religious dispute. Civil courts can't resolve religious disputes, so they can't defer to either side because that would be siding with one religious view and not the other. And so to do neutral principles is a way out of that dilemma. But all other cases are not of that sort. And in particular, Serbian Eastern Orthodox versus McLevebeck, that was not a church property case. It was a polity and employment case. It was a polity because the church in Europe took a large diocese and broke it into 3 parts, and the American officials said, no, you can't do that. Plus, the church in Europe fired one of the American ecclesiastics, and they said, well, you can't do that either. So it was about employment, and it was about polity. And neutral principles was argued, and the court said, no, we're not going to apply neutral principles. It's not a property dispute case. So let me let loose of that. Both Eric and Martin have a much longer list. So they violated the caution that I said at the outset, which I'll repeat. We're giving the church absolute authority, and that makes people nervous. So we need to be circumspect into how many zones we can historically and responsibly claim as a matter of church autonomy. And I know advocates with clients want to push the envelope and expand. But I think my 2 colleagues here, Martin and Eric, are expanding too much. And they're adding to my little list of 4, all of which are Supreme Court cases, by the way. They're referring to lower court cases for their expansion. But I think many of the problems that they point out can be resolved because they're in fact falling under the 4 categories that I have. For example, Martin mentioned the Bryce case. Well, the Bryce case was an employment case. A church dismissed their youth pastor. And but they needed to explain to their parishioners, and in particular the parents of the youth, why this pastor which was a well-liked pastor, was suddenly dismissed. And so at a congregational meeting, not the entire congregation, but a meeting for the parents, the church officials who dismissed the youth pastor communicated, so it was intra-church communication, why this youth pastor exercised some sexual improprieties and therefore was no longer suitable as a pastor and mentor to the children. Well, then the lover of the youth pastor who got fired sues for slander. Well, because of what was told to the parents. But what was told to the parents was necessary as part of the employment decision by the church, which I would protect fully. So in other words, the communication said to be slanderous was fully protected because it was about employment of a minister. So you don't need to add a new category. As to Eric's, you take, for example, Eric's first example there about non-ministerial employees who a minister chooses or wants to choose based upon a religious criteria in the hiring, and yet they can't do that under the church autonomy doctrine because the employee by definition is non-ministerial. I think that's a free exercise case. It's an exercise of free exercise to only hire people of like-minded faith to work alongside of and carry out the ministry of the organization. Now, if that free exercise claim runs up against Smith, well, my solution to that is don't go off and distort church autonomy doctrine. Get Smith overruled. I think it's tottering already. This is a good example of where we can finally get a majority of this court to overrule Smith.
Okay, Martin and Eric, y'all were both brought up. So Martin, do you want to go first and have any response?
Well, sure. And with regard to these additional subjects I've raised, I think they're quite important to the autonomy of the church. Take the issue of clergy malpractice. 39 courts, not the Supreme Court, but 39 state courts have found that they've barred clergy malpractice cases because it requires a civil court to define the standard of care for clergy practices. It's quite similar to the ministerial exception, but it's a little different. In both Simajati versus Paulson and Purdom versus Purdom, those were ecclesiastical tribunal cases, which are referred to in both Watson and Kedroff, refer to ecclesiastical tribunals. In both of those cases, things were said in confidential Catholic Church divorce cases that then resulted in defamation claims, and the court said, in fact, Purdom versus Purdom, it was a defamation claim by husband versus wife, and the court sua sponte invited the Archdiocese of Kansas City to intervene in the case because it recognized that this involved a very important ecclesiastical subject matter. So I do think we need to broaden these a little bit. Now, Carl's larger point, though, I think is really important, is what are the limits of the doctrine? And if we over-argue the facts, we're going to undermine the doctrine. So when Eric mentioned the janitor, janitors well understood their role in a church. Is they're part of the hospitality ministry of the church, and I think we could understand that to be an important ecclesiastical function and so on and so forth. But arguing for janitors to fall under the ministerial exception does threaten the viability of the doctrine. And one thing I found in my own argument, because the courts sense readily that I have a very expansive view of the church autonomy defense, is how do we articulate the limitation of this doctrine? Some years ago, Carl filed a brief in a case called Gibson versus Brewer in Missouri, which was a negligent supervision sexual abuse case, and argued that the court ought to adopt a standard limiting the doctrine to, I think you argued, Carl, malum in se, and that the court should not recognize negligent supervision, but intentional failure to supervise. That's a really interesting principled way to articulate the limits of the doctrine. But this is something I struggle with all the time, is how do we articulate the limits of the doctrine? There is some discussion also in Bryce where they say the doctrine's not unlimited, and they do have some discussion about that's interesting, and I'm sure some other courts do as well. But part of being sovereign and being a structural restraint is it's no more limited than if the president exercises his commander-in-chief powers in a stupid way. It doesn't take away those powers from him. So I would really welcome anybody's comments about how do you articulate the limits of the doctrine.
Martin, you're saying that there's not a federal district judge somewhere that would want to entertain an APA arbitrary and capricious claim and take over the commander-in-chief duties? That's interesting. Okay, Eric, you're chomping at the bit. What do you want to add?
I am chomping. Yes. So to respond to both Carl and Martin. So of course, people should not bring dumb cases. Like, that's the first rule of being a religious liberty litigator. Don't bring dumb cases. But first of all, just to respond to Carl's broader point, like, these are not disputes that usually the churches themselves are bringing up. In the vast majority of cases, they are the defendants. And so the question is, do they have a protection under the Constitution with respect to particular kinds of claims being made against them? I think it's a very interesting area of law because a lot of it bubbles up in the state court system as opposed to just being purely federal. But courts across the country automatically see the problems with interfering with the operations of, or the way that a particular religious organization works, and sort of interfering in that sphere. So this idea of sort of separate spheres of authority that Justice Thomas talks about, and the court talks about a little bit in the Our Lady of Guadalupe case, but in Justice Thomas's concurring opinion in the Catholic Charities Bureau case, he talks about separate spheres of authority. I think that courts across the country have an automatic sense that they are sort of going where angels fear to tread, or maybe where the angels should be treading and they shouldn't be treading. They worry about it, and they do get concerned about interfering with that space. So I don't think it's any sort of plaintiffs' lawyers putting up these sort of poor little churches to oh, you should think, let's bring some new cases on this issue. They're in a lawsuit that they don't want to be in, and they're trying to say, like, there's something wrong about having a court come in and tell me how to discipline so-and-so, or whether I can allow certain kinds of activity on my property, or I'm going to get sued. I think Bryce is a great example, because I'm pretty sure Bryce is not a ministerial exception case. I think it actually got decided on more church autonomy grounds. Obviously, Martin argued it, but I think it stands for the idea that there is this broader area. I'd encourage people to look at Luke's Notre Dame Law Review article that's coming out. Maybe, Carl, you need to write a response explaining why he's all wrong. I did want to correct one thing that I think Martin seemed to misunderstand about our position. We're talking about non-ministerial employees. So we're not saying that the janitor is a minister. And actually, I had a colloquy with Justice Kagan in the Our Lady of Guadalupe case, specifically about the issue of janitors at religious schools. And so, the sort of classic hypo is, what happens when the janitor shows up and starts wearing, down with Zionism, or I hate Israel, t-shirts while he's sweeping the floor at the Jewish day school? Is there any interference with the operation of that day school? Absolutely. And I think it sounds in church autonomy, not just in free exercise, because it interferes with the ability of that, the governance, the internal governance of that body. Now, I do think that there's a pretty significant difference between a ministerial exception kind of defense or claim in that area and a non-ministerial exception church autonomy claim, which is that in the ministerial exception context, you don't have to have a religious reason. Being a minister alone is enough to, say that governance is involved. I think in the case of the janitor, you have to say that you have a religious reason. Like, we are firing you for a religious reason, which is that you're interfering with the operation of our synagogue school by wearing around this very offensive t-shirt. That's different than saying you're a minister and therefore we just get to fire you for whatever reason. And that kind of gets back to one point, and I'll try to wrap up here, that I think Carl's view may be a little bit too simplistic, which is that I don't think that that the church autonomy doctrine is, in all of its different permutations, absolute. That is, if you don't have a religious reason in one of these kind of employment cases, you shouldn't win, right? Like, if you just try to fire the guy for some other reason, you're not going to get to interpose this. There's actually a great case that's sort of similar to my hypo about the janitor, involving an actual janitor at a Jewish day school, where the Jewish day school in Baltimore, it's Baltimore Hebrew Congregation case, said, well, he once told somebody what a sukkah was. It's African-American janitor at the Jewish day school. Therefore, he told them what the sukkah that he was building was, therefore he's a minister. And the court rightly throws that out. So I think it's definitely not absolute. And I don't think it's, I think if you don't have the religious reason, you shouldn't be able to bring that claim in the employment context. And I think that's true in some other areas too, right? Like discipline or things like that. I also think it's very important for everyone to realize, like, this is not some of these claims within church autonomy doctrine are going to be jurisdictional, and some of them are not. So ministerial exception, very famously, is not jurisdictional. The Supreme Court made that clear in the Hosanna Tabor case. But there's other claims and defenses that clearly would be jurisdictional. For example, deciding a theological question. No, sorry, Judge Starr, but you don't get to decide, whether, what vision of the Trinity is the correct version, as a civil judge. You can decide it for yourself and in your own life, but as a sitting federal judge, you don't get to decide that, and that's beyond your jurisdiction by definition. So I think it's really important to realize that it's kind of textured across these different kinds of claims and defenses that exist within the family of church autonomy doctrines. And I think that's pretty typical for First Amendment claims because free speech has a lot of different sub-doctrines. Free exercise does, Establishment Clause does. So I don't think we should be surprised at all that it's kind of different from claim to claim in church autonomy.
Hey, Judge Starr, if I might add something about the Hosanna Tabor and the jurisdictional issue.
Absolutely.
I think that I know it's 9-0, but and it's dropped in a footnote, but I think that was wrong by the Supreme Court to say that the ministerial exception is non-jurisdictional and that it has to be raised as an affirmative defense or it can be waived. And that there's other church autonomy doctrine applications that do receive jurisdictional treatment. And I think the reason I find that the most disturbing is that there's nothing more central to religious liberty than the choosing of the actual religious leaders. That's the most important, one of the most important religious liberties that we have is who will be our priest or pastor or rabbi or imam. And to say that somehow the government can adjudicate or who a church can hire and choose to be the leader of that church, who can be the bishop or the archbishop, to say that a court could adjudicate that absent a defense lawyer knowing to raise it as an affirmative defense or it would be waived, just seems absolutely ludicrous to me, especially when lesser issues and lesser concerns under the church autonomy doctrine, lesser positions might be defended under that doctrine outside of the ministerial exception and thus receive jurisdictional treatment. So I found that to be, somewhat, maybe that was necessary to get the 9 votes, but obviously quite disturbing, although the Sixth Circuit and some others have done some sort of artful judicial reasoning in order to create sort of the non-waivable affirmative defense to sort of mimic the jurisdictional nature that it should have been found to be. But here's where I just want to bring it back just a little bit, just to talk a bit about neutral principles and why I'm nervous about that. And I know Carl and everyone here agree. Well, Martin is probably with me on we don't want to do it at all. But Eric and Carl are probably they despise it, I would assume, based on what they've said and what they've said in the past, except for in these narrow sort of congregational church type property disputes. But the problem is that what I was trying to point out is that there's a migration towards this idea that churches are nothing special or different. The religion, religious institutions, synagogues, those sorts of things, there's nothing special or different or unique that judges can't sort of decide these types of issues. And my concern is that as you open the door to neutral principles, which frankly, until relatively recently was not a consideration by the court, even though it's cabined to property disputes in certain types of circumstances, again, Jones versus Wolf 5-4, it does invite this kind of, well, as a judge, I think I can sort of decide these things. I mean, I think Justice Rehnquist, I know a lot of people like him and like a lot of decisions he's made. I do too. I'm a big fan, but unfortunately he was wrong in 1976 when he said the court could adjudicate canon law to decide whether or not a bishop was defrocked properly or not. And he was trying to apply neutral principles and ultimately succeeded in Jones versus Wolf in property dispute, but that doesn't mean that there's not the urge to extend that. And then what's a property dispute is part of the other question, is the control of the entity itself, which then controls the property. Is that a property dispute? that's really what's going on in property disputes. It's not about fighting over title. It's about fighting over control of the religious entity itself. And I think that that's a very dangerous road to go down. But anyway, I'll stop here because we probably have to have time for questions.
Yeah, well, let me ask a question based on your comment on the footnote in Hosanna Tabor. Does everyone on the panel agree with Hiram that the footnote is questionable?
No,
I think that the footnote is
no.
correct and that this doctrine is not jurisdictional and can be waived.
Well, the footnote 4 is certainly troubling, but it can be read so as to be not harmful. When it referred to jurisdiction, just say it was referring to Article 3 jurisdiction because we're a federal court, and so federal courts get their jurisdiction from Article 3. So in that sense, church autonomy is not emanating from Article 3, but it is emanating from the First Amendment. So every church autonomy case is structural, and that's what really matters. So yes, there's Article 3 jurisdiction for a federal court to deal with church autonomy cases, but they have to deal with the doctrine as structural. And that means if it's a church autonomy case, you've got to dismiss it outright. And I disagree with Eric saying some church autonomy cases aren't absolute. I think they all are because they're all structural. I've got some other responses, but let me just come back. Martin was saying, where is the definition of the outer scope of church autonomy? Well, it's the Chief Justice Roberts outlined it in Hosanna Tabor, and then it was reaffirmed again in Our Lady of Guadalupe. But it's a historical test, and in particular, it's how the patriots the reasons by which the patriots at our founding rejected the model of an established church as the Church of England. And out of that, Michael McConnell, another professor, says that there's 6 different elements of that. And I've certainly used that, as has the Supreme Court, in particular Justice Gorsuch. And I think we should follow that historical guidance. In that article, which came out 10 days ago of mine, which Judge Starr mentioned at the outset, I unpack some historical occurrences at the founding that aren't mentioned in Hosanna Tabor. And again, they're pointing to what's autonomous and what is not.
Okay, so I'm going to ask our audience to put any questions that might be percolating in your minds into our chat. We'll have a few minutes here to get to those. There's one that we've got so far that I want to bring up and raise to the group, and then I have a related one after to get to if we have time. So the question is, how about fire and brimstone speeches in a house of worship by a pastor or rabbi? Is that protected speech? So we've been focusing on church autonomy as the doctrine that draws from multiple clauses in the First Amendment, but how about the interplay of speech?
Well,
Yes.
of course it's protected by the autonomy doctrine. That's why I include speech and communications as one of the ecclesiastical subject matters that are protected. This comes up in a lot of cases. Eric referred to, I think you have a case involving the confessional privilege. I had a case some years ago involving a Lutheran pastor who was dealing with a boy he thought wrongly accused of participating in a gang murder. The boy's conscience came awake during his conversation, and he confessed the murder. The DA subsequently, and the Lutheran Book of Order says that pastors shall preserve inviolate all confidence is reposed in the care of souls. This beautiful phrase, care of souls. And we made a church autonomy argument. It was at a trial court level. There's no published precedent. But certainly that would be protected by the autonomy doctrine. And a lot of communications are protected. And if someone wanted to give a fire and brimstone speech and announce who was saved and who wasn't saved and who's burning in hell, they get to do that. That's what freedom looks like.
I doubt there's any disagreement about that one, Judge Starr. And I also think that we probably don't disagree about the waivability question that you were talking about. I think there's probably a disagreement about whether the court was right to say that it's not jurisdictional to bring the ministerial exception defense. But I think we all probably agree that it is not a waivable thing precisely because of the kind of structural things that Carl was talking about.
Okay, and let me ask a spinoff from the audience question, though. There's been a federal regulation for a while involving ministers and endorsements, right? And so it's one that I know is frequently disregarded in Texas, but the Trump administration is currently acting on that. And so question, do you think church autonomy doctrine would run over that regulation if it were still on the books several years from now, and if it were enforced by the federal government?
Well, Judge
against
Starr, look,
it?
we try to get those cases. We had pastors recording their endorsements, sending it to the IRS, and saying, please come after us so that we can have our case and knock out the Johnson Amendment. Unfortunately, the IRS would not take the bait. They did not want to lose their power of intimidation, I guess, and have it actually adjudicated. So, hopefully Judge Barker is able to, get this resolved with that consent order, and we can be done with the one that's in Texas, that between the Department of Justice and the plaintiffs there. But hopefully we can get that resolved. But it was always covered by the church autonomy doctrine. The government had no business regulating what a pastor said from the pulpit. And for the argument to be that, well, they're getting a tax exempt status, and therefore to enjoy the privilege of that, you have to give up some sort of freedoms or whatever. Pharaoh didn't even tax the priests. All right, nobody has taxed the priests pretty much from the beginning of civilization across continents and across various religions and over thousands of years. So I find that argument to be extremely baffling.
Very good. Okay, no further open questions. So let me just ask, is there sort of a parting quick thought that our panelists have? Carl, can I ask you to go? Well, just ask in the batting order. We may have covered everything we intended to cover, but parting closing thoughts.
I think Carl's next article should be a full-throated critique of the stupidity of Jones v. Wolf, so we can cite it in our next brief.
I will say Carl is right from a very pragmatic perspective, and we have to keep that in mind when we're doing our cases, and we do here at First Liberty, that because of the increasing secularization of our society, and then ultimately the judiciary from which they're drawn from the society and from our culture, that we have to be careful in the way that we articulate and manifest these our defense of the church autonomy doctrine in terms of the way we talk about it. But I don't think that we can waver from its fundamental foundational truth, which is that the government has no business telling religious entities how they should organize and run their affairs. And I think that's what Thomas Jefferson was really talking about when he was writing to the Baptists, that it was the wall with the knives facing away from the church, not towards the church, which is that the church would be free to live out its life, free from government interference and objection.
Well, that's a good note to end on. So we will end it there and hand the baton back to Kayla.
I would just like to issue thanks to our panel. We really appreciate you taking this time out of your days and sharing your expertise and insight. It was a fabulous discussion, and I'm sure we could have gone on for longer. So really appreciate you taking the time. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsoc@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.